Thank you both for coming this morning, and good to see you both. My opening question would be, do any other countries or trading blocs other than the EU operate trade agreements that involve dynamic alignment or the equivalent?
If I could respond to that, I've looked into this and I can't find any example anywhere in the world that is like what the EU does. Even Australia and New Zealand, which have very strong mutual recognition, they don't have dynamic alignment in the sense of a rule taker and a rule creator. Canada and the US do not have this. There's one agreement that Canada and the US have that is a little bit like that, but even that is more consultative. So this is a EU concept, and to my knowledge, it doesn't exist anywhere else in the world. It's something that the EU has with its trading partners.
The EU has a lot of it. It goes back to the EEA agreement, which is the testing ground for quite a lot of this.
There are no others?
No. But I would just add on the back of that actually the lessons that the EU have learnt from the EEA agreement, including the problems with the operation of dynamic alignment, have been rectified in some of the much more recent treaties.
So maybe to sum up those answers and the good, interesting answers you've given before, I think everybody is keen to reduce trade friction. But this particular mode of doing so is, as Professor Barnard described earlier, a pretty hard, extreme way, and it involves giving back control over your laws in sectors where they export much more to you than you do to them. No one else does it. As Professor Barnard said, the TCA was designed explicitly to avoid it, and you pay up for the privilege ahead of time, for example, by giving up 12 years of fish. But would it still be sort of excessive to call it, as some are doing, extortionate?
Well, that's difficult to answer. I'm not sure in what context it was called extortion, and I would need to see the final price tag. It seems odd to me that the United Kingdom, as the country that receives more imports from the EU than vice versa, would be the rule taker in this regard. Wouldn't it make more sense that the United Kingdom would require the EU to be aligned with its laws, given the nature of the trade flows? That would seem to be more natural to me, but I don't feel that, particularly since that it's not a model that's copied anywhere in the world among countries that have very, very healthy trading relationships with each other, including Canada and the US. It would seem to me to be excessive just from the standpoint of sovereignty. Why would a country surrender its sovereign right to create regulations specific to its own economic needs simply to have access to another country's market, when indeed it is offering more lucrative market access than it is receiving, given current trends?
I ask.
Did Professor Barnard didn't have a chance to.
Thank you. I would just say, I think, two practical points. One, size matters. And the reality is that the EU is a regulatory hegemon and therefore sets standards which it expects everyone who trades into its market will comply with. Secondly, of course, the EU is still our largest trading partner, and so therefore UK companies still look to EU rules to comply with them. That's my first point. My second point is that if you look at what's happened post-Brexit in terms of regulatory de-alignment, and by that I mean departing from EU rules, there were, we think, probably about 7,500 EU rules on the UK statute book at the time of Brexit. About 3,000 or so have been amended or repealed, but there's still 4,500 or so which still apply in the UK. And in fact, that number has remained pretty consistent from the time of Rishi Sunak as Prime Minister onwards.
Could I just clarify what you said? I believe you said that this is the price for trading with this regulatory hegemon. But how many countries around the world haven't been asked to, don't have dynamic alignment, with the EU and trade very happily with it, and in fact are growing their trade and so forth. Isn't it the exception that you get asked to do dynamic alignment, not the rule?
In that context, to add to it, could I just, you may not be able to answer this, but I was reading about the Australia-EU trade agreement this morning. I mean, are you aware of dynamic alignment featuring in that at all?
No, it does not. The Australia-EU agreement does not. And it's true, the Australia-EU agreement has somewhat limited market access, and that may precisely be the reason. And I'm not going to say that CETA being another example, the Comprehensive Economic Trade Agreement between Canada and the EU, I'm not going to suggest that Canada would have the equivalent market access that an EU member state would have, or that a partner that's engaging in dynamic alignment would do. But if I may, the focus here is too much on the friction. Too much issue is being paid attention to the border friction of trade. And clearly dynamic alignment would work towards reducing frictions, maybe even eliminating it. But that's ignoring the much, much larger problem that no one seems to want to look at, is the damaging effect that the EU regulations will have internally on this country if they're adopted. The regulations themselves are anti-growth and anti-prosperity, and that far outweighs any benefit that will arise from the reduced friction at the border.
Thank you very much. Lord Jackson.
Thank you, Lord Chairman. Can I first of all observe that I think this is partial, this will include partial involvement or participation in the single market. So to a certain extent, it's a breach of Labour's manifesto at the election. That's my observation, but you may want to comment on that or not. But can I ask some specific questions around this main question? What is decision shaping in this context? Because that is something that we've been told is going to be a weapon, not a weapon. That's a bit pejorative. A strategy that we can use. What does it mean in practical purposes? Do you think inevitably the UK's involvement via dynamic alignment will mean propping up the EU's cohesion policy and financial contributions? Is that inevitable? Because it will go into a big pot rather than offset economic imbalances across the EU. And will we have, in your view, with I concede that you haven't seen the legislation yet, but will we have a practical veto such as the Norwegian veto on the Postal Services Directive, which they exercised and which was subsequently withdrawn? And my final question, I know I've got a lot of questions here, is do you foresee something happening that's never happened before, I don't think, which is that the EU would say to the UK, we are going to withdraw some access to the single market if you don't adhere to your legislative commitment for dynamic alignment? Because it hasn't happened before. Do you think it's likely that it would happen?
Mr. Barnard, do you want to start?
Yes.
No?
Shall I start?
Yes, please, yeah.
Thank you for those multiple questions. If I try and break them down into groups, in respect to your observation that this is a breach of the Labour manifesto's commitment that we won't go back into the single market, the limited dynamic alignment that is proposed in the common understanding really does not touch the core of the single market. The core of the single market covers free movement of goods, persons, services and capital, and the areas that are under discussion, energy, SPS, youth mobility, really do not touch anywhere near the core of the single market. In respect of your question about decision shaping, this is actually a rather interesting one, and I wonder if I might refer you to the Swiss agreement. Now, there's been a package of Swiss measures updating their earlier agreements, and the way the Swiss agreements, its agreements plural, work is that the institutional arrangements are now appended to each separate agreement. So I've got in front of me the agreement on free movement of persons, where the institutional arrangements are appended at the back. And this spells out what decision shaping actually means for Switzerland. And specifically, and rather strikingly, it says that the Commission shall inform Switzerland of a draft proposal. It shall informally consult Switzerland's experts in the same way that it asks for the views of experts from the member states of the Union for the drafting of its proposals. So Switzerland will be involved in the drafting, or at least consulted over the drafting. However, what does not happen is that once the decision process shifts from the drafting phase to getting into the tunnel of negotiations, then Switzerland is absolutely kept out of the door. My understanding is that a very similar approach is taken in respect to the EEA states too. And the question is, to what extent will we be able to piggyback on the provisions in the new Swiss agreements so that we can be involved in decision shaping? I've also done some asking of my colleagues from these countries about how influential they are in respect to decision shaping. What differences does it make? Views vary, it must be said. Some people say they do listen to us, particularly if we send very high-quality experts, because the Commission respects high-quality input. Others say they listen to us, but ultimately, if it's an important EU principle at stake, they will not follow us. But the Swiss government gave an interesting example of where decision shaping did lead to a change in legislation. It's a legislation on the carrying of firearms. And essentially it was a ban for general public carrying firearms. But there's an issue in Switzerland about those doing military service. And an amendment was made to the directive to allow for those doing military service to be able to take their firearms back. So there are examples, I wouldn't say a lot, but there are examples where decision shaping does lead to a change. In respect of your question about will we have a veto, well, in fact, essentially there is a de facto veto in the EEA agreement and also in the Swiss agreement. In the EEA agreement, as you probably know, the jargon is about the two pillars. And in respect of the two pillars, what you see is that the EU says a measure is EEA relevant. And then once it is designated as EEA relevant, then it goes to the joint committee between the EU and the EEA EFTA states to decide if it really is EEA relevant and whether it should be incorporated into the EEA annexes. And if so, then it has to be implemented. In fact, there are 600 plus pieces of EU legislation which have never gone through that process, including some rather significant pieces, including on deposit guarantee schemes and on GMOs. So in fact, there is a sort of break in the EEA agreement, which happens because of the blockage in this process I've just described. In respect to the Swiss agreement, as I said, it's not a automatic dynamic alignment, and it expressly foresees a situation where Switzerland says we're not having that rule. And the the Swiss agreement then makes provision for what they call compensatory measures. And in respect of those compensatory measures, essentially it's agreed up front that if the Switzerland refused to take on board a new provision on, say, free movement of persons, and then compensation will be that they will be blocked in respect of something to do with that area of the agreement. So it's not quite a veto, but there's flexibility.
Just for clarification, you referred earlier on to the tunnel of negotiations. What does that mean? Is it a term of art?
No, I think what I just mean is that
Tim's been in the tunnel many times.
I think I've been stuck there.
I think maybe it'd be better for Tim to explain what the tunnel means rather than... I'm not using any technical...
I just wanted to make sure...
Basically, what I mean is there's a draft text and then it goes to... If it's ordinary legislative procedure, it goes to the Council and the European Parliament. They probably will try and do it through the trilogue process, which is an extraordinary process, which only insiders will have actually seen how what's known as the sausage factory actually makes the sausages. But it's at the making of the sausages stage that there is no involvement by the Swiss and the EEA.
Thank you. I should declare an interest as Professor of European Politics at Cambridge University, but I'm also on the Management Committee of the Centre for European Legal Studies, of which Professor Barnard is the director. But I don't have any financial interests to declare. Before I turn to the question you've got on your exam paper, essentially, question 3, could I just ask for a bit of clarification? And I realise that we haven't exactly got a glossary of terms that might be helpful for members of the committee. But if, and I don't want to preempt questions 10 to 13, but when we're talking about alignment of rules, are we only talking about regulations, or could we be looking at directives where we're talking about framework legislation? And that was one of the areas where, when the UK was a member of the European Union, we were sometimes accused of gold plating. But are we looking at legislation where we would actually have to decide precisely how we enshrine it into British law?
That's better for you.
Thank you. So traditionally, when we're talking about dynamic alignment, if you look at the EEA agreement, that's the Norway agreement, it covers both legislative acts and non-legislative acts. Legislative acts, I realise this jargon is not very transparent, but legislative acts are acts adopted via the so-called ordinary legislative procedure, and it will cover regulations, directives, and occasionally decisions. But in addition, it also covers so-called non-legislative acts, which are, in UK speak, secondary law, which are adopted under the legislative acts. This terminology is difficult. But the interesting question, and perhaps is implicit in what you were asking, is what about case law of the Court of Justice as interpreting those legislative acts and the non-legislative acts? And the combination of dynamic alignment plus the rather clunky term of the duty of homogeneity, which is strongly there in the EEA agreement, requires essentially that the Norwegian, Liechtenstein and Icelandic courts follow the case law of the Court of Justice as well, as indeed must the EEA EFTA court. And you see that also being followed through in, the, for example, the more recent Swiss agreement.
Thank you. And then the very specific question that was sort of wondered about was something like the Product Regulation and Metrology Act, where the UK government can specify that meeting an EU product regulation constitutes this meeting a UK one. Is that dynamic alignment? Is that what you would call unilateral dynamic alignment?
I think that's probably a fair way to characterise that. That is not obligatory, but it's deferential to EU law, so it's presumptively valid, but there's no obligation to do so. So I think, yes, if you wanted to use that term, I think that would be correct.
I would go one stage further. I'd say unilateral dynamic alignment obviously is the choice of an individual state, and we now have powers to do it. The problem for the UK, for UK manufacturers, is still it doesn't mean that they have greater market access. Mm-hmm. What it means is that, yes, they only have to comply with one set of rules rather than two. Think of the case of the CE marking and whether we should have our own version of CE marking, which, as we know, has somewhat fallen by the wayside. Because it means now that the UK manufacturers can manufacture according to that one set of rules, but nevertheless, because we do not have conformity assessment, that wasn't in the TCA, that means that in the absence of conformity assessment, widgets made in the UK to EU standards have got to be tested by assessment bodies in the EU to check that they conform to those EU standards, which again adds to costs. And one of the things that going forward, the area which seems to me to be ripe for further consideration, if the EU would accept it, is something to do with conformity assessment, because we already have so much alignment, and the Product Regulation Metrology Act will facilitate that further.